On what grounds was Shrien Diwani acquitted of his murder charge? Could a different court have ruled otherwise? Was it fair not to call Shrien Diwani to testify? And what are the similarities between Shrien Diwani and Oscar Pistorius' cases? What time is it? It's question time. Hello and welcome to the program. My name is Bongi Kwala. In from Port Said today, British businessman Shrien Diwani has arrived back in the UK, a free man. This after being cleared by a South African court of orchestrating the murder of his bride during their honeymoon in 2010 in South Africa. Judge Jeanette Traverso threw out the case, saying it was riddled with contradictions. The 34-year-old has always denied plotting to kill his wife Annie while they were on honeymoon in Cape Town. My guest today is Advocate Zahir Omar from Zahir Omar Attorneys, and joining us on the line is Advocate Mthunzi Maga, the spokesperson for the Justice Department. Before we can discuss this further, let's take a look at this insight.
After a 4-year wait, the Western Cape High Court recently acquitted United Kingdom businessman Shrien Diwani for his 2010 murder of his wife Annie Diwani. Deputy Judge Jeanette Traverso ruled the prosecutor's argument had fallen far below the required level to secure a conviction. Meanwhile, South Africa is counting the costs of Shrien Diwani's extradition from the United Kingdom for this trial. The whole process is estimated to have cost the country over 4 million rand. To Annie's family, the fact that Shrien was never called to testify was in itself a miscarriage of justice. They have expressed their shock and dismay.
Knowledge of not ever knowing what happened to my dearest little sister on the 13th of November 2010. That's going to haunt me, my family, my brother, my parents for the rest of our lives.
According to the Criminal Procedure Act, an accused can be declared not guilty at the close of the prosecution case. This is if the court feels there is insufficient evidence to show he or she committed the crime. Fact is, according to a court of law, Shrien Diwani is now a free man.
Indeed, Shrien Diwani, a free man. Let's start with Advocate Mthunzi Maga, who's on the line right now representing the Department of Justice. Advocate Maga, what do you make of this? It's taken the NPA around about 3.5 years to 4 years to bring Shrien Diwani to South Africa. He gets here, he spends a few months, he gets acquitted, he goes back home. What is your take on this?
Good afternoon, Bongani, and good afternoon to counsel there at the studio. I think of importance, Bongani, is the fact that we've always been alive to the fact that our efforts and all the resources and money that we've channeled into ensuring that Diwani comes to South Africa were only meant to ensure that he is brought to justice and gets to answer all the serious allegations of his involvement in the murder of his wife, in terms of what the NPA had as a case that convinced the UK authorities to grant the extradition for him to come to South Africa. We were also alive to the fact that justice is defined as a fair adjudication of legal issues with a proper and correct interpretation and application of the principles of criminal law insofar as this case is concerned. And justice is not confined to a conviction. It is also an acquittal if there is a proper application of the law. So insofar as from a perception point of view is concerned, yes, there was an expectation that because of the resources that were channeled to this case, there should have been a conviction, but that's not how we operate, and that's not how we view it. It can never be overemphasized how important human life is. That's why for us, though it's not an easy decision to take, because we would have loved him to respond, at least take the stand, but the witnesses faltered.
You reach a conviction, Advocate Manga, because you do your job diligently as the NPA. And Judge Traverso here saying that, this was so improbable with so many mistakes, lies and inconsistencies. You cannot see where the lies ended and the truth began. Really, it means that the state was nowhere near ready to take on this case.
You you are wrong, Bongani, and why you are wrong is because on paper, prosecutors make prosecutorial decisions because of evidence that's in statements taken by the police. They read the statements, they interview or consult with witnesses, and once they are convinced with what they have, which is what Advocate Mob and his colleague were, and the entire NPA were, now that's the first stage. That's prosecutorial decision-making process. And you can also go as far as interrogate the very evidence that you have, cross-examine your own witnesses when you interview them before you even take it to court. But the crucial and most important stage is that of them testifying in an open court where they have to stand the test of time through an interrogative cross-examination by the defense attorney. Now, there are two things that happen in a criminal trial during the testimony of a witness. Either she or he comes out as a star witness like Zek Modise in the Oscar Pistorius case, or he or she comes out bruised like Sefier, who was telling lies about correctional facilities in the Oscar Pistorius case as a defense witness whose evidence was thrown out.
Advocate, we'll come back to the similarities between these two cases, but I would like to bring forward here Advocate Omar so that we begin to understand really what went wrong here.
Comrade Gwala, look, Judge Traverso found that she has no evidence before her upon which a reasonable court will convict. Number one, before any accused is charged in our country, a decision must be made to charge the accused. That decision, in terms of Section 179 of our Constitution, is made by the Director of Public Prosecutions, i.e. the DPP. So one, we have the DPP of the Western Cape, having applied his mind, Advocate Rodney de Kock, by the way, studying a very competently prepared police docket by our police force. He made a decision.
Did you say comprehensively prepared?
I'm saying a very competently prepared docket by our South African police. I'll elaborate shortly why.
Sure.
Don't ever blame the police. Never. Our police did a sterling job. The DPP applied his mind, resolved to charge Shireen Divani. Shireen Divani's legal team did not review, in terms of Section 1795D of our Constitution, the decision to charge him for inter alia conspiracy to murder. The matter was placed before the Honourable Judge Hlophe. Judge Hlophe, the Judge President of the Western Cape. He accepted the version of the events conveyed to him by Mr. Tonga, who is now languishing in prison, and Mr. Mngeni, who now passed away. Mr. Kwabe, I understand, was given indemnity, which I'll explain later on. But the fact of the matter is, we have the DPP, a senior officer of the court, the judge president, with more than 30 years' experience, who applied his mind and who found that there is a reasonable possibility of a conviction of Divani if Tonga and Mngeni testify against... Sorry.
I just want you to hold it right at that, because after you've given us this opening remark, really, I want to find out where did it all go wrong. But we have to take a quick break, Advocate Omar. Just hold on for me. And then Tunzimaga on the line, please just stay with us as we take this quick break.
Had there been harmony between the South African government and the Nigerian government, which came through in the latter stages, the bodies would have been repatriated quicker.
Now, we always get a lot of criticism as a public broadcaster, but just how far can media go in terms of reporting the facts?
Watch Media Monitor Sundays at 9 a.m. on the SABC News Channel.
Welcome back. You are still watching Question Time here on SABC. Today, my guests are Advocate Zahir Omar from Zahir Omar Attorneys, and on the line we have Advocate Ntunzi Maga, who is the spokesperson for the Department of Justice. Let me come back to you, Advocate Omar. We're still unpacking that Judge Hlophe then accepts that there is a case to be made here, that Shireen Diwani must stand trial, isn't it? Is that what you are saying?
One, the Director of Public Prosecutions made a decision finding there is sufficient facts in the police docket to link Shireen Diwani to the commission of a crime. Number two, Judge Hlophe accepted the versions of Tonga and Mgeni, and on that basis gave a more lenient sentence to both Tonga and Mgeni, and accepted that they will testify in court. Number three, Shireen Diwani himself and his legal team, represented or led by Advocate Van Zyl SC, did not apply to court to set aside the decision of the DPP to charge Shireen Diwani criminally. Judge Traverso had a discretion. A discretion is as wide as the horizon. She found that she believes no court will, on the facts, convict Shireen Diwani on the evidence presented to her. In doing so, Judge Traverso finds that the DPP is wrong, the Judge Hlophe is wrong. She finds that Shireen Diwani, who accepted that he has a case to meet and to give his version to the court about, was also wrong.
But if the accused here in this particular case are not giving evidence that is satisfactory to the judge, I mean, what else can the judge do?
Let's examine the objective facts, Mr. Wala. Number one, Shireen Diwani was given bail. He feigned mental illness for 3 or 4 years, costing us a fortune. Number two, Shireen Diwani leaves the scene where his recently wedded wife is murdered very quickly. Shireen Diwani finds the police station in Khayelitsha, a foreign country. Number four, Shireen Diwani becomes intimate with people who confess to having been involved in his murder. Number five, strange people from a strange country implicate Shireen Diwani in paying them to have his wife killed. These facts, amongst others, are itself sufficient, coupled with the decision of learned Judge Hlophe, the DPP, and Shireen Diwani himself and his advocate, who not once told the court that there are no facts in the docket linking him to the murder. These facts were alone sufficient for Judge Traverso to have refused the application for a discharge and to have told the court that if Shireen Diwani does not testify, there's a real risk of him being convicted. Instead, Judge Traverso, it's widely reported, was harsh to Advocate Mop, and in fact, in open court, made the remark that there is only one material witness underpinning the state's case, and that's the testimony of Tonga, which is uncorroborated. That was, with respect, a hint to Advocate Van Zyl to close his case, and that created the perception of bias.
Advocate Maga, do you concur? Do you find any resonance with this, or you beg to differ?
But I was still explaining to you, I wasn't necessarily doing a comparison of the two cases when you cut me earlier. All I was saying was that naturally in a court of law, which is what happened in respect of the Mr. Diwani's case, is that witnesses can come out being star witnesses or they come out bruised. Now I'm saying in respect of this matter, the judge found that the credibility and the manner in which they testified and the evidence elicited from them by the state was not sufficient for Mr. Diwani to even respond. And I want to concede to say, having listened to the judgment and read the judgment, I'm convinced that prosecutors did all that they could, but they were disappointed or let down by the witnesses. And there's not much that they could have done beyond.
So this case was built on the witnesses alone. Is that what you're trying to tell me?
Cases are built on evidence that either real evidence or documentary evidence or oral evidence in the form of witnesses. So in respect of this one, yes, there were witnesses, but they faltered and they were not convincing to the judge. This is why Mr. Diwani was granted a 174 application and it was discharged.
Because Advocate Maga, when the judge refused to admit the issue of Diwani's sexuality, then the NPA began to crumble, so to speak. They built their case around that, and that was led much earlier in the beginning of the trial. And after that, they didn't have anything to say, but relied on these suspects who are in court right now, who are in jail actually. And when they gave the discrepancies as they were trying to build the case, it crumbled immediately.
My point exactly to say, on paper and upon interviewing and consulting with the witnesses, which was before trial, the case looks good, as it would in other cases that prosecutors deal with on a daily basis. And it's not unusual that when it comes to them testifying crunch time, when you need them most, they just let you down, which is what happened here. And the fact that there was the evidence of I don't know, that guy from the UK was rejected or not allowed by the court. And there were other witnesses which were accomplice witnesses, which are the ones that faltered. And even when that decision was taken, you approach that with caution, knowing very well that, accomplice witnesses are people who will admit or confess or to criminality themselves.
All right.
So there's an element of caution that is exercised by any judge in evaluating that evidence.
Advocate
so I'm
Omar,
to you.
Yeah. Yes. All right. Let me move on to Advocate Omar quickly here, because I want to understand, where was this case lost?
I, on behalf of the Society for the Protection of Our Constitution, sent a letter to the DPP, Advocate Rodney de Kock and Advocate Mop. I asked him to please let me know whether an interpreter was used, competent, who understood the home language of Tonga and Kwabe. I was asked how many interviews were conducted by Advocate Mop. I asked why didn't Advocate Rodney de Kock, the DPP himself, present the case on behalf of the state. Up to now, no response. I asked the DPP to apply for a postponement so that the society and the public, who are all expressing interest and have expressed outrage at, one, the fact that the learned judge appeared to be biased, number two, the learned judge assisted the defense to study the docket and to apply for a recusal. My learned friend Advocate Maga, with respect, is wrong. Section 34 of our Constitution provides that all disputes must be adjudicated before a court of law in a fair public hearing. Here too, I respectfully say, Judge Trevers was wrong. The concerns of the public underpin our entire administration of justice. When she found that she has regard to the concerns of the public, but she found that if she surrenders to the concerns of the public, it would cause chaos, that was, with respect, wrong. Section 34 of our Constitution confirms that. Section 179 imposes an obligation upon the minister to have final say in prosecution authority. The National Director of Public Prosecutions ought to have intervened very early when there was a public outcry to investigate the efforts of preparation and presentation by the DPP in the presentation of the case.
All right. When we come back from the break, I just want us to check if the NPA can actually appeal this. Don't go away. Question time takes a break. We'll be back with you just shortly.
Nkandla falls apart. Nyana, your views on this headline today?
I think it's a bit of a disappointment that after so much money was spent on making sure that that the president is secure, such things can happen.
We are not having a non-security installation here. This is a security fence which was built with millions falling apart. Nkandla represents a cesspit of corruption. It was to be expected that you have such occurrences.
What has corruption got to do with cows grazing?
A fence.
Across a fence.
They have started recruiting some members out in Cape Town, up to 109 members. George, your views?
First of all, it creates a sense of not being safe. The very fact that they exist amongst us can easily make us to be a target of all sorts of attacks. The people who are looking for ISIS might be coming to South Africa.
Watch Media Monitor with me, Alicia Jali, Sundays at 9 a.m. only on the SABC News Channel.
Welcome back. You are still watching Question Time. My guest today, Advocate Zahir Omar from Zahir Omar Attorneys, and on the line, Advocate Ntunzi Maga, the spokesperson for the Department of Justice. Let's look at this point of appealing, Advocate Omar. Can the NP, is there an appetite first, insofar as the NP is concerned, to relook at this matter and appeal, if it means that?
The Director of Public Prosecutions must appeal. There are many grounds, but one I will state on air. Judge Traverso, with respect, applied wrong law in the conclusion of a judgment. The law she applied are guidelines for the Director of Public Prosecutions to determine whether to charge an accused or not. It was not the law relating to a 174 discharge. What Judge Traverso ought to have applied a mind to is whether Shireen Divani going into the box may strengthen the state's case, amongst other things. She had a discretion as wide as the horizon, particularly in view of Divani having had access to the entire state's case, coupled with the findings of Judge Slope, coupled with the decision made by the DPP. I'm submitting with respect, another court will find that Judge Traverso wrongly applied the law regarding Section 174 applications. If the DPP does not apply for leave to appeal, then the National Director of Public Prosecutions must intervene. If the NDPP does not intervene, then the Minister of Justice, in terms of Section 179, subsection 6 of our Constitution, has an obligation with respect to intervene and to ensure that an application for leave to appeal is brought.
But Advocate Maga says they've done everything they could to make sure that there's a conviction here, but they, like in any other case, I mean, there are two sides to the story, and their side then did not win the day. So what else do you want to see being done?
In my respectful view, there's been a complete failure of justice. In fact, there was no trial. How can Judge Traverso, sitting alone, sit as a court of appeal over the findings made by Judge Slope and the DPP? If a person wants to review a decision to prosecute, then that person must apply for a review in terms of Section 179, subsection 5, subsection D of the Constitution. If indeed it is found that Advocate Mop, who presented the case on behalf of the state, was a lame duck, as reported in the media, then there's been a complete failure of justice. A court must set aside the entire proceedings and order that it start de novo.
All right, Advocate Maga, is there an appetite on your side really to relook this matter from the minister's point of view down to the NDPP, down to the DPP in the Western Cape?
Two things, Bongadi. Adrian Mop is one of the best prosecutors the NPA has ever had. And he was allocated this case with full confidence of everyone involved and senior management of the NPA. So to say that he should have been led by Advocate Rodney Cock, I don't think that's fair. Secondly, there's no appetite to appeal because there are no grounds upon which an appeal can succeed, given the fact that the judge based her decision on an evaluation of the quality of evidence as well as the credibility findings that he made against accomplished witnesses. So there's no appetite, and procedurally we cannot appeal that because it should only be an appeal on a point of law. In the respect of this one, it was an evaluation of evidence and credibility of witness.
But Advocate Omar argues that constitutionally this case is appealable.
I think the problem here is that when you put in 5 lawyers and give them one question, you get 5 different responses. And my response is, no, there's no appetite and the procedure hasn't kept.
So it's closed in as far as the Justice Minister is concerned?
Yes, it is closed.
All right, and Advocate Omar, this case is closed insofar as our Justice Ministry is concerned, and the whole justice system here in South Africa.
Reasons for refusal to apply for leave to appeal must be furnished to a member of the public or an association representing the interests of the public.
What can be done to reopen this case?
It's simple. If indeed Advocate Maga is right that the National Director of Public Prosecutions and the Minister have resolved not to apply for leave to appeal, then a member of the public or the deceased family or any association, organization, human rights organization in our country must applied to court to review the decision of the minister and the NDPP to refuse to apply for leave to appeal. During that review decision, a court hearing the review will have regard to the grounds for the appeal to decide whether, in fact, the minister, with respect to the minister and the NDPP, in making such a rash decision so quickly, are correct. I will respectfully submit and ask Advocate Maga and our learned minister, study the transcript, elicit comment, and tell the world and the public whether Judge Traverso correctly applied the test for discharge, a 174. Why did Judge Traverso allow Shrin Divani to walk out of court without giving his version, despite Advocate Van Zyl putting into the court that his client will come in the box and give his version?
It would appear, though, that the Hindochas and his family have moved on right now. They are looking into the UK courts to assist because they're feeling that the South African courts have let them down.
You see, Advocate Maga, you know, when foreigners come here, they have a nice time, but they should not do that. We are a young democracy. We're only 20 years old. Here's our constitution, it's still developing. But to smear our entire system, our country and our police force with one brush and to run away is wrong. But my concern is not the Ndocha family, with respect. My concern is our country, which we struggled for and which we have now. My concern is the failure of our courts to hastily give attention to Section 179.
I'm going to be very hasty here because I don't know if I'll be able to bring Advocate Maga here. But quickly, the similarities between this case and the case of Oscar Pistorius. That one has been appealed. It's going to to Bloemfontein right now. Can we draw any similarities?
One, both were victims, both were women. Both were dispensed with by means of a murder.
But in terms of the law?
In terms of the law, we have a very competent prosecutor assigned, who I will describe as a law machine, Gerinel, to Oscar's case. We had Advocate Mop, whom the media described to have been a lame duck. As far as the law is concerned, we have Learned Judge Masipa today agreeing that she may have been wrong. But Judge Traverso made a decision in disregard to findings by the judge present and making a finding saying there's no case for him to even meet. So I'm saying the differences between Traverso J's judgment and Masipa's judgment. There was no one in the public who accused Judge Masipa of being biased. There are approximately 23,000 people on Facebook who are saying Learned Judge Traverso was biased and acted harshly, unnecessarily to Advocate Mob. There are huge differences which I'll elaborate upon if I have more time.
I guess also there's a lot of social interest in this particular case, but because there's no one appealing right now, so we will never know if Judge Traverso will change his mind and say, maybe I was wrong. But thank you very much for joining us. That's Advocate Zahir Omar of Zahir Omar Attorneys. And thanks also to Mthunzi Maga on the line from the Department of Justice. And question time for today. Thank you very much for joining us, and a big thank you to our guest and you for watching the show. We welcome your feedback via email on questiontime@sabc.co.za, or you can tweet us. Our Twitter handle is @questiontime24. From me and the rest of the crew, you have yourself a wonderful time. Goodbye.